before turning to the delegation. Welcome, sir, and you have the floor.
谢谢。
Thank you, Madam Chair. According to the Basic Law of Hong Kong Special Administrative Region of People's Republic of China, the provisions of the ICCPR that are applicable to Hong Kong SAR continue to be effective after the 1st of July 1997 and shall be implemented through the laws of Hong Kong SAR. For the time being, China is not a state party to the ICCPR. Yet, in order to fully observe the principle of one country, two systems, and to let the committee and the international community better understand the implementation of the applicable provisions of the convention in Hong Kong SAR, the Chinese government, in line with the convention, on January 1999, January 2005, and April 2011, respectively, submitted to the committee through the Chinese delegation in Geneva 3 reports that were prepared by Hong Kong SAR independently based on the applicable provisions in the convention and had successful review sessions with the committee. In September 2019, the Chinese government once again, in line with the convention and through the delegation in Geneva, submitted to the committee the 4th report of Hong Kong SAR, which was, as usual, prepared by Hong Kong SAR government independently. A delegation of Hong Kong SAR, led by Mr. Cang Kuo-wei from the SAR government, participates in the review session today. The detailed information regarding the report will be presented by the head of delegation, and the questions raised during the review session will be answered by him and other members of the delegation. Thank you, Madam Chair.
Thank you very much, Your Excellency, for your statement. I will now give the floor to the head of the delegation, Mr. Tang Kwai, for his opening statement.
As a Secretary for Constitutional and Mainland Affairs of the Hong Kong Special Administrative Region Government of the People's Republic of China, that's the Hong Kong SAR government, I have the great honor to have this opportunity to address you on the implementation of the International Covenant on Civil and Political Rights in the Hong Kong SAR. First of all, I wish to thank Ambassador Chen Xu, permanent representative of the People's Republic of China to the United Nations office at Geneva, and other international organizations in Switzerland for making the necessary arrangement for our attendance online and for his kind introductory remarks. This year marks the 25th anniversary of the establishment of the Hong Kong SAR. The Hong Kong SAR is an inalienable part of the People's Republic of China. We are a local administrative region that enjoys high degree of autonomy under one country, two systems, and comes directly under the central people's government of our country. Over the past quarter century, the Hong Kong SAR has been implementing one country, two systems, which has been proven to be the best institutional arrangement to ensure Hong Kong's long-term prosperity and stability, and to serve the fundamental interests of our nation. As President Xi Jinping stated that the policy of one country, two systems, having been tested and proved time and again, enjoys the full support of more than 1.4 billion people of the motherland, has the unanimous endorsement of the Hong Kong residents, and is widely recognized by the international community. The legal basis for implementing one country, two systems is the Constitution of the People's Republic of China and the Basic Law of the Hong Kong SAR. The Constitution of the People's Republic of China and the Basic Law provide constitutional guarantee for fundamental rights and freedoms, including the right to equality before the law, and is buttressed by the rule of law and an independent judiciary. Article 39 of the Basic Law further provides that the provisions of the ICCPR as applied to Hong Kong shall remain in force and shall be implemented through the laws of the Hong Kong SAR. Safeguarding human rights and freedoms is a constitutional duty of the Hong Kong SAR government. The government attaches the utmost importance and is firmly committed to the protection of human rights, which has been upheld firmly and across the board by all our government bureaus and departments. Today, I have some other key representatives of the Hong Kong SAR government, and they are Mr. Llewellyn Mui, Solicitor General, and his colleague, Mr. Welon Loy, both from the Department of Justice. Mr. Esmond Lee, Deputy Secretary for Education. Mrs. Shirley Yong and Mrs. Apollonia Liu, who are Deputy Secretaries for Security. Mr. Joe Chen, Deputy Commissioner of Police. And Mr. Raymond Ho, Deputy Commissioner of the Labor Department. Madam Chairperson, as we see it, our submission of the periodic reports to a committee, the subsequent response to the committee's list of issues, and these meetings are all very good opportunity to promote our mutual understanding with the international community. In the process of compiling the fourth report, we have widely consulted members of the Legislative Council, NGOs, and members of the public. Such consultation process and exchanges have also helped heighten our community's general awareness and interest in the covenant and human rights issues. I wish to express our appreciation to the committee for your list of issues issued in August 2020. The questions raised in the list have given us the opportunity to provide clarifications and updates relating to some key areas after the submission of the fourth report to the committee in September 2019. I would like to highlight two critical developments in recent years to help illustrate our government's commitment to firmly upholding the principle of one country, two systems, while safeguarding people's rights and freedoms. They are the enactment of the Law of the People's Republic of China on safeguarding national security in the Hong Kong SAR in June 2020, and the improvements to the electoral system of the Hong Kong SAR made last year. Allow me to take you back to 3 years ago, to June 2019, when the Hong Kong SAR faced unprecedented challenges, which have derailed one country, two systems and paralyzed the government. For those of you who are familiar with Hong Kong, it would be no exaggeration to say that that was the darkest time of Hong Kong. For almost one whole year, Hong Kong was held hostage by the rioting mobs. Citizens witnessed regular outbreaks of serious riots across the city. Never before had our society seen such violent scenes, with thousands of petrol bombs being thrown, with fire sets on sundries, citizens holding views different from the mobs being attacked viciously, public properties and facilities being vandalized, and widespread blockage of traffic. The Legislative Council building was stormed and seriously damaged by a violent mob. There were blatant attempts to incite Hong Kong's independence and of foreign interference. There was a type of horrible menace that innocent Hong Kong citizens were facing at that time. Such acts of secession, violence, terrorism, together with foreign interference in Hong Kong's affairs, seriously jeopardized national sovereignty, unity, and territorial integrity. Ensuring national security is the responsibility of all governments. to stop and suppress those violent, subversive, and terrorist activities so as to safeguard the long-term prosperity and stability of Hong Kong and uphold the one country, two systems regime. The Standing Committee of the National People's Congress timely and resolutely adopted the law of the People's Republic of China on safeguarding national security in Hong Kong SAR in June 2020. As a matter of fact, the Hong Kong National Security Law upholds the rights and freedoms of Hong Kong people, as well as the high degree of autonomy of the Hong Kong SAR. It clearly stipulates that Hong Kong SAR shall protect the rights and freedoms enjoyed by residents under the Basic Law and the provisions of the ICCPR and the International Covenant on Economic, Social, and Cultural Rights as applied to Hong Kong in accordance with the law. It also stresses the rule of law, including the presumption of innocence, the right to defend oneself, and protection against double jeopardy. The above notwithstanding, it is a well-known principle that many rights and freedoms recognized in the ICCPR are not absolute and may be subject to restrictions as provided by law if it is necessary for protection of national security, public safety, public order, and rights and freedoms of others, etc. The effect of the Hong Kong National Security Law is obvious and direct. The civil unrest in Hong Kong has since subsided. Street violence substantially reduced. The law has restored peace and stability. People return to their day-to-day life in peace, and society has returned to normal. The economy has begun to recover, except for the reason of the pandemic. For example, since the implementation of the Hong Kong National Security Law until this April, funds raised through initial public offerings in Hong Kong SAR had increased by 30%. And the average turnover of the stock market had lifted by 60%. Comparing 2020 with 2019, the value of assets under management for the asset and wealth management industry surged 20%. No doubt, Hong Kong national security laws has effectively restored stability in our society and helped Hong Kong come out of the shadow of violence. It should also be stressed that in Hong Kong, no person is above the law. The status, wealth, political power, or background of anyone are all irrelevant. Law enforcement actions only target on criminal acts, and they are all based on evidence, strictly according to the law and for the acts of the persons concerned, absolutely having nothing to do with their background. Hong Kong is renowned for having a fair and mature criminal justice system. The principle of prosecutorial independence by the Department of Justice is constitutionally guaranteed. When adjudicating cases, the judges in Hong Kong remain independent and impartial in discharging their judicial duties, free from any interference. Judgments are also made public with elaborate reasoning on decisions. National security and political security are inseparable. The emergence of acts and activities endangering national security was fueled by persons conspiring with external forces who managed to get their way into public offices through open elections. Those people made use of their status of their public offices to obstruct or even paralyze the operation of the government and glorified the violent acts of rioters trying to sway public opinion to bring down the government. Some even colluded with external forces to undermine both our country's and Hong Kong's security and interests. The chaos exposed loopholes and deficiencies in Hong Kong's electoral system at the time. The National People's Congress, by having recourse to the Constitution of the People's Republic of China, made provision not only for the city's good governance, but also for the sustained success of the one country, two systems policy. Given the situation that arose in Hong Kong 2 years ago, the National People's Congress acted legitimately in making adjustment to Hong Kong's electoral system that was absolutely necessary to rectify the problems. In March 2021, the National People's Congress adopted the decision on improving the electoral system of the Hong Kong SAR, which provides a robust systemic safeguard for patriots administering Hong Kong. In accordance with the decision, the Standing Committee of the National People's Congress then adopted the amended Annexes 1 and 2 to the Basic Law. Pursuant to the decision and the amended Annexes 1 and 2 to the Basic Law, the Hong Kong SAR government enacted local legislation to implement the improved electoral system. The new electoral system, while amending and improving the electoral methods for the Chief Executive and the Legislative Council, further introduced a mechanism for reviewing the eligibility of candidates for election committee members for the office of the Chief Executive and for members of the Legislative Council. This series of institutional mechanisms put in place legal safeguards to ensure a full application of patriots administering Hong Kong. Keeping political power in the hands of patriots is a political rule commonly practiced in the world. No one in any country or region in the world will ever allow political power to fall into the hands of forces or individuals who do not love or even sell out or betray their own country. Since then, 3 public elections under the improved electoral systems, namely the Election Committee Subsector Ordinary Elections, the Legislative Council General Election, and the Chief Executive Election were conducted smoothly in an open, fair, and honest manner. The improved electoral system represents a quantum leap in terms of unprecedentedly broad coverage and balanced composition of public voices of all walks of life in the Election Committee, and consequently, the Legislative Council compared to previous terms. Business leaders, grassroots organizations, representatives from neighborhood committees, representatives of associations of Hong Kong residents in the mainland, and the Hong Kong representatives in relevant national organizations are added to the Election Committee composition. Membership of the Legislative Council is also increased from 70 to 90, spreading across different backgrounds and political spectrum. This enables all social sectors to be represented in a fair and balanced manner. The new legislature is now rid of extremists who wish to obstruct or even paralyze the operation of the government without any intention of entering into constructive dialogue to represent the interests of all Hong Kong people. There is popular support for early solutions to long-standing livelihood problems. The newly elected members have been displaying commitment to serve the interests of Hong Kong wholeheartedly. The quality of legislative scrutiny and debates, as well as the efficiency of the Legislative Council, have significantly improved. Let me also take this opportunity to point out that the democratic process of Hong Kong has really started only after China's, our motherland's, resumption of the exercise of sovereignty in 1997. The democratic development of Hong Kong is clearly defined under the Basic Law. It stipulates that the method for selecting the Chief Executive shall be specified in the light of actual situation in the Hong Kong SAR and in accordance with the principle of gradual and orderly progress. The ultimate aim is the election of the Chief Executive by universal suffrage upon nomination by a broadly representative nominating committee in accordance with democratic procedures. Citizens' rights, such as the right to vote, to stand for election, and the rights and the freedom of speech and the press are well enshrined in the Basic Law. The exercise of these rights is well protected, consistently with the provision of the ICCPR applicable to Hong Kong. This year marks the 25th anniversary of the establishment of the Hong Kong SAR and our reunification with our motherland. With order restored by the Hong Kong National Security Law and the electoral system improved, it is high time for Hong Kong to start a new chapter of development, one that guides Hong Kong from stability to prosperity. The HK SAR government will continue to work with the whole community to fight against the pandemic, improve people's livelihood, strive for economic development, build a caring and inclusive society, integrate Hong Kong SAR into the overall development of the country, as well as join hands with relevant parties in promoting the opportunities brought about by the Guangdong, Hong Kong, Macau, Greater Bay Area, and our country's 14th five-year plan, thereby expanding the room for development of young people and injecting impetus into Hong Kong's development. Madam Chairperson and distinguished members, we look forward to fruitful and constructive exchanges with the Committee on the Hong Kong SAR fourth report in the light of the ICCPR. Thank you.
My thanks to His Excellency Mr. Chan Kwok Wai for his opening statement at the outset of this constructive dialogue, and also to His Excellency Ambassador of China for his opening remarks as well. Ladies and gentlemen, we will proceed this morning with the constructive dialogue with the representation, the delegation of Hong Kong, China. In this segment, we will be addressing issues 1 to 9 of the list of issues. As you know, this will be held in three different segments. So this segment is related to issues 1 to 9 of the list of issues. I will give the floor to the members who have asked to take the floor and ask questions to the delegation of these issues. And the first speaker on my list is Mr. Bulkin. You have the floor, sir. And of course, I remind my colleagues who will be taking the floor on the need to keep their time as far as possible. Mr. Bulkin, over to you, sir.
Thank you, Madam Chair. And good morning, Excellency and members of the delegation in the room. And good day, good night to members of the delegation in Hong Kong, China, and all those following online. I'd like to welcome you to the review by the Human Rights Committee of the 4th periodic report of Hong Kong, China, which was submitted in February 2020, but unfortunately delayed because of the pandemic. I regret that this will be conducted online, but the committee has been preparing for this for some time now. So I hope that the technical difficulties perhaps and other challenges of this format will be minimal. Since the last review in 2013, as mentioned by the Honorable Secretary in your opening statement just now, Hong Kong, China has experienced significant challenges, both socially and politically, in the past few years, but challenges which I may add directly impact upon our mandate. Therefore, this review comes at a particularly important juncture of Hong Kong's affairs and history. To that end, I am confident that the goal of both the committee and Hong Kong, China is the same, which is to ensure the faithful implementation of the covenant for the benefit of all residents of the Special Administrative Region. In that spirit, I look forward to a constructive dialogue among us over the next 3 days So without further ado, let me turn to the list of issues which you have before you. And I will begin with issue number 1. I wish to begin by seeking some clarification of the constitutional system of Hong Kong, China. I will address what seems to be the gradual erosion of the model of one country, two systems, and its promise of conferring on the residents of Hong Kong, China, the ability to govern their own affairs, and what this means for Hong Kong, China's obligations under the covenant. The reply to the list of issues asserts broadly that Article 158 of the Basic Law entrusts its interpretation to the Standing Committee of the National People's Congress of the PRC. However, the language of Article 158 is not so open-ended. According to the text, the power of interpretation applies only to provisions of the Basic Law which fall within the responsibility of the Central People's Government or which concern the relationship between CPG and the region. Moreover, any such interpretation must first be sought by the courts from the Standing Committee. Therefore, where the NPC Standing Committee has issued such interpretations when these prerequisites have not been satisfied, what is the source of their power to do so? One example of this is the 2017 co-location decision, which permits Chinese law to be applied within Hong Kong's West Kowloon Express Rail terminus. In this situation of creeping jurisdiction by the Central People's Government, notwithstanding the clear language of Article 22, which preserves the autonomy of the special administrative region, how does Hong Kong, China guarantee the rights of its residents and ensure the protections of the covenant? A most concerning issue is the promulgation by the Central People's Government of the National Security Law in June 2020. I note, Honorable Secretary, your comments about the events that precipitated this law. But I must observe that it was done overnight, without consultation, and bypassing the local legislature in circumstances that are not covered by Article 18 of the Basic Law. In fact, Article 23 of the Basic Law expressly confers authority on the Hong Kong Special Administrative Region to enact laws relating to treason and sedition. So this is a clear area falling under the jurisdiction of the Hong Kong SAR. However, Article 65 of the NSL states that the NSL takes precedence over Hong Kong's laws and entrusts the NPC Standing Committee with the final say on the interpretation of the NSL. Hong Kong's highest court has confirmed that when local laws are inconsistent with the national security law, the national security law will prevail. This has significant implications for Hong Kong, China's obligations under the covenant, since the Basic Law incorporates, as you told us, and guarantees fundamental rights and freedoms for Hong Kong residents. Honorable Secretary, as the prioritization of domestic law over the ICCPR is incompatible with the obligations of the covenant, please explain how these provisions of the NSL asserting its primacy can be justified. Further, since Article 4 of the NSL protects human rights guaranteed under the Basic Law and the ICCPR, while at the same time the national security law allows mainland law enforcement to enforce national security laws within Hong Kong, can we assume in practice that mainland law enforcement will necessarily respect the human rights obligations in the covenant, particularly protections related to arrest and detention, fair trial rights, and the freedom from cruel and unusual punishment and torture? What recourse exists for residents of Hong Kong, China, whose rights may be violated by mainland law enforcement while operating in the special administrative region. Please explain how Hong Kong, China deals with situations in which interpretations of the Basic Law by the Standing Committee are not in conformity with the Covenant. Finally, on this issue, given the dramatic scope of the national security law, such as its criminalization of criticism of the Hong Kong, China government, and the extraordinary jurisdiction asserted, please clarify whether the entirely legitimate engagement of civil society organizations with this committee for this periodic review would be regarded as a violation of the national security law. Can you provide assurances that the CSOs who participate here today and over the next 3 days are not in danger of prosecution or victimization under the NSL for such engagement? Turning now to issue number 2, regarding the mechanisms to protect and enforce human rights in the SAR, the replies to the list of issues assert that there is no need to establish any additional human rights institution as the existing mechanisms function well. However, of the bodies mentioned in the reply, the Equal Opportunities Commission, for example, applied for accreditation with the Global Alliance of National Human Rights Institutions in 2000, but it was considered non-compliant with the Paris Principles and awarded C status. Specifically, the EOC is not independent, nor can it function as an NHRI, as its mandate is not comprehensive, even as an equality body. Likewise, independent assessments point to the lack of power and independence of the Ombudsman, another body that is mentioned in your reply. There are instances where public authorities, such as the police, have blatantly refused to comply with recommendations from the Ombudsman. The independence of this office is also questionable because of its failure to properly monitor actions of the police, such as supporting the police's refusal to disclose details on the procurement, deployment, and composition of chemical weapons, as well as the police force's refusal to provide the names and identification numbers of police officers who were suspected perpetrators of human rights abuses. This highlights the failure of the Ombudsman to take account and/or inadequate understanding of relevant constitutional requirements, as well as international standards, which raises questions about its competence in investigating complaints of maladministration, especially when it comes to matters of high political sensitiveness. These examples indicate that the existing mechanisms referred to in the reply are inadequate to monitor and protect the rights protected by the Covenant. And it confirms the need for an independent NHRI with a comprehensive mandate and appropriate powers. Accordingly, please inform us whether there is any intention to address this deficiency, and if not, why not? Further, and in the meantime, given some of these inadequacies in the existing mechanisms as identified, will consideration be given to strengthening these institutions to ensure their independence and effectiveness? And finally, for this morning, I turn to issue number 6 of the list of issues. Even though the committee's previous concluding observations had expressed concern at the overly broad definition of the offenses of treason and sedition, there was no attempt to limit their potential scope since then. In fact, for the first time in decades, the colonial era law of sedition was resuscitated in 2020 and has since been deployed against activists, academics, journalists, and ordinary members of civil society simply for exercising basic rights of freedom of expression and assembly. The public record indicates that a growing number of persons have been arrested, charged, and convicted for sedition relating to innocuous acts such as publishing children's books, simply clapping in court, or chanting slogans like "Liberate Hong Kong," or criticism of the government's COVID-19 response on social media. All activities that occur and are accepted in democratic societies. These are legitimate exercises of protected free speech rights under the ICCPR. In a democratic society, individuals have a right to criticize the government, and sedition laws should not be used as a pretext to silence opposition. Moreover, because this is considered a national security crime, the stringent provisions of the NSL have been applied to those charged, leading to a denial of bail, weakened fair trial rights, and expanded law enforcement powers of search and surveillance without judicial oversight. Can you explain for us how such a draconian response is compatible with the commitment under the Basic Law and Article 39, which you have referenced several times, to guarantee the rights enshrined in the covenant and ensure that they are implemented throughout the special administrative region? Please note that the ICCPR only permits restrictions to expression and assembly rights insofar as these are necessary, reasonable, and proportionate. In light of that, please explain for the committee how activities such as chanting slogans, clapping, and criticism of government policy, which are all legitimate exercises of free expression, constitute national security crimes. What is the precise nature of the threat posed by such harmless activities to justify their criminalization, and activities which can only strengthen governance? Please explain how the overly broad offenses of sedition and treason, as well as the definition of foreign political organizations or bodies, will be modified to ensure that they are compatible with the obligations under the covenant. Finally, paragraph 45 of the reply to the list of issues indicates the intention of Hong Kong, China to address these definitions in the context of the legislative exercise for Article 23 of the Basic Law. Please inform us exactly how this will be done. Specifically, will Hong Kong, China undertake meaningful and widespread consultation prior to enactment? Will Hong Kong, China incorporate these concerns and those of civil society, as well as any of the committee's recommendations that will be forthcoming, into any new law? Finally, will Hong Kong, China commit to reviewing the pending sedition cases to ensure that no one is prosecuted or targeted for legitimate acts of peaceful political expression? I thank you very much, and I look forward to your replies. Thank you, Madam Chair.
Thank you very much, Mr. Bulkin. The next speaker on my list is Ms. Sanson. Madam Sanson, you have the floor.
Thank you, Madam Chairperson, and good morning to the members of the mission in the room, and greetings to the members of the delegation in Hong Kong. I will be today dealing with issues number 3, 7, and 8. And let me assure you that I have carefully studied all the information provided in the core document, report, replies to the list of issues in relation to the 4th periodic report. And I thank you for this information. So I would like to receive today additional information or news about recent developments. Concerning issue number 3, I fully agree with the statement of the Hong Kong, China in its replies that adopting legislation to safeguard national security is an inherent right of every sovereign state. And I understand that the national security law was adopted within this ambit. It is, however, just as important to emphasize that a number of rights under the ICCPR are absolute and non-derogable and must be ensured and protected in all circumstances, even should the state of emergency be declared in accordance with Article 4 of the Covenant, which hasn't been declared in Hong Kong, China in the period under this review. Thus, even the rights and freedoms that are not absolute remain fully in force and must not be unduly restricted and limited, even when pursuing the goal of protection of national security and/or public order. So in addition to the questions posed by Mr. Bulkan, and in light of some reports that the national security law would prevail even over the basic law in some instances, thus overriding the fundamental rights and freedoms ensured under the Covenant, could the delegation please further clarify the relationship between the Covenant and the national security law, and explain whether the rights under the Covenant are fully ensured and protected in all conduct undertaken under the national security law, in law and in practice, without any exceptions? And moreover, could the delegation please explain how could one possibly challenge the constitutionality of the national security law? I also wish to thank Hong Kong, China for providing us with explanations on the definitions of 4 categories of offenses under the national security law, namely secession, subversion, terrorist activities, and collusion with a foreign country or with external elements to endanger national security, which, however, did not dispel all my concerns as to their interpretation in practice. I wish to note here also that my colleague, Mr. Gomez, will address the issues of appointment of judges to handle cases concerning offenses endangering national security and the issue of jury trials. I wish to, however, express my concern over the statistics we received showing that the National Security Police had in 2 years arrested 201 individuals aged between 15 and 90 for allegedly endangering national security as of 30th of June 2022. So as of today, as of a few days ago, this is the statistics, among which 125 individuals and 5 companies were charged in the cases concerned. And in particular, I'm concerned about the information that 25% of the charged persons are younger than 20 years, 9 of them underage, 3 only 15 years old. Further, all the 12 suspects whose cases went to trial and were concluded have been convicted. So we are dealing with a 100% conviction rate. And I also note that 44 persons charged with sedition were charged with sedition, as raised also by Mr. Bulkan, not falling within one of the 4 above mentioned categories covered by the national security law. In light of this, could the delegation possibly provide us with sentences that were handed down for 12 already convicted individuals? Comment on the observations that the perusal of the national security law leads to conclusion that the elements of mentioned offenses are interpreted overbroadly and applied arbitrarily without ensuring all the guarantees under the Covenant? Moreover, could the delegation please explain what reasons justify that more than half of the 83 persons have been remanded for more than 1 year, the longest even 660 days? And to further follow up on Mr. Bulkan's question, I would appreciate the explanation on how the national security law was adopted. I wish to receive more concrete information on how the views of Hong Kong residents and various sectors of community have been taken into account, as you have submitted in paragraph 24 of the replies and repeated in the opening statement. Possibly also if you could provide us with any statistics on various activities undertaken for this purpose. Could the delegation please comment on reports that travel documents are being confiscated for indeterminate period of time within the ambit of the national security law, thus effectively preventing individuals from leaving the territory of Hong Kong, China in violation of their covenants rights? And finally, could the delegation please update us on whether there have been any assessments conducted on the national security law or are planned in the future, and perhaps whether you're planning any amendments to this law. Turning now to issue number 7, I wish to thank the Hong Kong China for all the information supplied on the anti-discrimination legal and institutional anti-discrimination framework and its implementation in practice. Nevertheless, I would appreciate if the delegation could provide us with information on whether any discussions on adopting comprehensive anti-discrimination law, which would prohibit all forms of discrimination, including direct, indirect, multiple discrimination in all spheres, in both the public and private sectors, on all the grounds prohibited under the covenant, including on the basis of sexual orientation, gender identity, or sex characteristics. In paragraph 52 of the replies, we were informed that Hong Kong China intends to bring all government functions and powers within the scope of race discrimination ordinance. So could the delegation please indicate any concrete steps taken in this regard, in particular in relation to the Hong Kong Police Force and the Hong Kong Correctional Services Department? I wish to acknowledge the information on the number of the complaints received by Equal Opportunities Commission under the Racial Discrimination Ordinance till 31st of August 2020. And I have to note with surprise that out of 19 cases, 18 were discontinued and no unlawful acts were found. So I wonder if any aggrieved person sought assistance from the EOC to make civil claims in court. Could the delegation please also provide us with the statistics for the last 2 years, so after the end of August 2020, and the outcomes of such complaints procedures? And finally, would it be possible to obtain any information on any complaints brought under the other anti-discrimination ordinances, so the Sex Discrimination Ordinance, Disability Discrimination Ordinance, and the Family Status Discrimination Ordinance? And turning now to issue 8. According to the information we received, there exists no laws which protect the rights of members of LGBTI community in Hong Kong, China, and thus individuals have often relied on judicial authorities to exercise their rights. I know the decisions of the Hong Kong High Court in this respect. However, measures that were adopted under the national security law has also led many LGBTI activists to flee to the United Kingdom specifically, while many LGBTI figures have also been arrested or jailed for their participation in political protests. In May 2021, the Court of First Instance ruled that same-sex partners can apply for equal parental rights over their child when one of them is the biological parent. And while this ruling recognizes parental rights in some situations, many other forms of parenting, where there may not be biological connection to the child, are left out of the purview of equal parental rights. Further, the High Court has also held that same-sex couples in Hong Kong have no constitutional right to marry under the territory's basic law or other domestic human rights protections, and that therefore the government was under no obligation to provide any alternative form of legal recognition that would essentially endow them with equivalent rights. And despite the setting up of the Interdepartmental Working Group on Gender Recognition in 2014 and carrying out the consultations in 2017, I wish to note lack of any information that the Hong Kong government made any progress towards drafting a gender recognition law. And the court also upheld a government policy requiring transgender people to undergo surgery before having their gender legally recognized, which violates their right to highest attainable standard of health and their right to privacy. Could the delegation thus please provide us with any update on any legislative developments for the recognition of transgender person and clarify the compatibility with the covenant of certain requirements for the legal recognition of gender reassignment, such as the deprivation of reproductive ability and gender confirmation surgery? I would appreciate also information on any measures taken to protect LGBTI persons from hate speech and hate crime, whether there were any awareness-raising campaigns conducted in this regard, And how have the equal opportunities for people of different sexual orientations and gender identities been promoted in practice? Are there any measures planned to facilitate the holding of the events, such as gay pride parades? And I would also appreciate clarification from the delegation on what concretely it means a practical and reasonable manner that is referred to in paragraphs 60 and 61 of the replies for treatment of transgender persons. And finally, could the delegation please clarify the distinction in practice between applying the principle of single cell occupancy referred to in same paragraphs for transgender persons from their solitary confinement? Thank you very much, Madam Chairperson.
Thank you very much, Ms. Sansin. The next speaker on my list is Mr. Furuya. You have the floor, sir.
Thank you, Madam Chairperson. Good afternoon to the members of the delegation who are in Hong Kong, and good morning to the members of the delegation here in Geneva, and also to my colleagues. I would join my colleagues in thanking the delegation of Hong Kong, China for participating in this meeting and having a dialogue with us for 3 days. Today, I'm going to address the issues in paragraphs 4 and 5 of the list of issues. I start with the issue of paragraph 4, which also addresses national security law. Under the national security law, over certain serious cases. According to the reply to the list of issues, the enforcement acts performed by the staff of the office is not subject to the jurisdiction of the Hong Kong SAR, but they must abide by the law of the Hong Kong. It seems to me this explanation is ambiguous. Please clarify whether the office and its staff must act in accordance with the Hong Kong Bill of Rights and also relevant provisions of the covenant, and provide information in what manner the enforcement acts by the central government staff are subject to judicial review or other judicial challenges if those acts are allegedly carried out in violation of the covenant. Article 29 of the National Security Law criminalized such acts like unlawfully provide state secret or intelligence concerning the national security and provoking by unlawful means hatred among Hong Kong residents toward the Central People's Government. However, the definitions and elements of these crimes are very vague and general. Please indicate concrete measures the Hong Kong government has taken to ensure that the criminalization of those acts would not infringe the rights under the covenant, including the freedom of expression and the right of peaceful assembly. In June 2020, pursuant to Article 43, Paragraph 3 of the National Security Law, Chief Executive issued new implementation rules for the purpose of applying to the investigatory measures that will be taken by the new created National Security Division of the Hong Kong Police Force. Hong Kong, China explained in its reply that the power provided for in the rules are generally in line with existing police powers, which contain the necessary safeguards. However, Schedule 1 of the implementation rules allows the Hong Kong police, under certain conditions, to engage in warrantless search of physical property and electronic devices of the individuals with alleged connections to national security law crimes. Pursuant to Schedule 3, the Secretary for Security has the authority to reason the property of individuals being investigated for alleged national security law crimes without obtaining a court warrant to do so. The Schedule 4 also authorizes the police to order that online content posted on the local website be removed when the publication is likely to constitute an offense endangering national security, and no warrant is needed under certain conditions. Please explain what measures Hong Kong government has taken and is taking to put implementation rules into practice in a manner compatible with Hong Kong's obligation under the covenant, and also indicate what judicial remedies are available to the persons whose rights guaranteed under the Hong Kong Bill of Rights and the covenant are violated by the measures taken under the implementation rules. The committee received information that some organizations located outside Hong Kong received a letter from the Hong Kong police accusing of their violating the national security law and demanding takedown of their website. Please explain on what grounds national security law is extraterritorially applicable to the website of which contents are entirely lawful under the domestic law of the countries where those organizations are located and in light of international standard, and therefore to be protected under the covenant. Now I move on to the paragraph 5 concerning the legal framework for state of emergency. Under the emergency regulation ordinance, on any occasion which chief executive may consider to be an occasion of emergency or public danger, he may make any regulations whatsoever which he may consider desirable in the public interest. This means the chief executive has the power to issue emergency regulation on the ground of public danger, which is different from a state of emergency that threatens the life of the nation, as Article 4 of the Covenant provides for. In fact, when imposing the mask ban in October 2019, Chief Executive stressed that Hong Kong was not in a state of emergency. Please clarify the difference between the public danger and the state of emergency under the Emergency Regulation Ordinance, and explain how Hong Kong, China considered restrictive measures taken by the Chief Executive under the situation of public danger is compatible with Article 4 of the Covenant. According to the General Comment 29, measures derogating from the provisions of the Covenant are limited to the extent strictly required by exigencies of the situation. This requirement relates not only to the necessity of such measures in certain situations of emergency, but also to the principle of proportionality. Hong Kong, China clearly admits these principles in its reply. However, it seems that the Emergency Regulation Ordinance itself does not provide any such requirements to be satisfied. Please provide information on the safeguards to preclude unnecessary or disproportionate restrictions of human rights in the circumstances of public danger or emergencies under the Emergency Regulation Ordinance. Lastly, please provide information on the measures taken under the Emergency Regulation Ordinance or on other legal basis in response to COVID-19 pandemic, particularly whether the Hong Kong government or central government declared the derogation under Article 4 of the Covenant, and if not, how to harmonize the restrictive measures taken with the Hong Kong's obligation under the Covenant. Madam Chairperson, this ends my question. I would highly appreciate the answers from the delegation. Thank you very much indeed.
Thank you very much, Mr. Furuya. And the final speaker on my list for this morning is Mr. Gomez. Mr. Gomez.
Gracias, señora.
Thank you, Chair. With my first remarks, I would like to greet the delegation of Hong Kong and to thank them for their availability and willingness to meet with this committee in order to speak about the human rights situation in the Special Administrative Region. I would also like to thank all the entities that have participated in this process for their commitment to the International Covenant on Civil and Political Rights, one that we are all bound by, and that surely enough will be strengthened in terms of its efficiency and its results as a product of this constructive dialogue. Today, in this session, I simply want to ask about one issue, and that is domestic violence or violence against women, which is issue 9 of the list of issues. In its previous concluding observation of 2013, this committee recommended to Hong Kong, China, to redouble its efforts to combat domestic violence. In many ways, among them, ensuring the efficient implementation of the ordinance or the decree on family violence and relations of cohabitation. In this regard, Hong Kong, China should guarantee providing assistance and protection to the victims, as well as the criminal prosecution of the authors and awareness raising about this issue among the whole society. This committee is pleased to note that on March 1st, 2016, the law on domestic violence entered into force. The delegation of Hong Kong, China, would you mind informing the committee on the following aspects that relate to the implementation of that law? First, how many women have lost their lives since then, victims of a crime of violence against women? Can the delegation of Hong Kong, China provide us broken down data to answer this question? Secondly, how many protection warrants have been requested since the entry into force of this law? How many have been granted? Third, once a protection warrant has been granted, how is its enforcement followed up on? Fourth, are there police units as well as units of prosecutors and judges that are specialized in this type of offenses? Are there training courses on this type of offenses for police officers, prosecutors, and judges? Are civil and criminal aspects related to violence against women treated jointly in one single court? What social or psychological assistance services are provided to victims? Are there public campaigns to prevent violence against women? And has any monitoring been done to evaluate the results of these campaigns? Is there an observatory on violence against women, where data on violence against women are gathered and centralized? And then, is there an authority that coordinates the actions of all authorities working in the area of violence against women? Thank you very much for your attention, and I look forward to receiving your replies.
Thank you very much, Mr. Gomez. So this concludes the first round of questions which have been raised by my colleagues this morning. I now suggest, as per the program, to have a 10-minute break for the delegation in Hong Kong to prepare their responses to this to these questions. So we will have a 10-minute break and resume this meeting at 11:20 Geneva time. Okay, so this meeting is suspended for 10 minutes.